Good evening to all those people that are now joining. Welcome to the CIArb Northwest Branch 2021 Construction Law Update. We're delighted that Keating Chambers has agreed to present this 2021 update, and I'd like to welcome our speakers, Harry Smith and Tom Coulson. Harry will be speaking first, and he specialises in construction and energy disputes. He's recognised by the Legal 500 as a rising star. Harry's appearances for successful parties in the High Court include the cases of Aqua Leisure and Benchmark, Synergy Gas and Northern Gas, and John Johnson and Eagle Building Services. Harry will be speaking on insolvency and adjudication tonight. Tom has a busy practice also in domestic and international construction, engineering and energy disputes, together with associated professional negligence and insurance matters. Tom is described as a rising star at the construction bar, and he offers great analytical skills, and his recent experience includes Imperial Energy and Daylight Power and Thomson Taylor Wimpey. Tom will be speaking on liquidated damages. So there will be questions and answers at the end, and I invite anyone that wishes to ask a question during this talk to post it in the question and answer box so it can be picked up at the end. The session is also being recorded, and only the participants that are on screen can be seen and heard during that. So with that, I'd like to hand over to Harry and welcome Harry, Tom and Keating Chambers to tonight's talk.
Great, thanks very much for that introduction, and thank you all for joining. I'll just share my screen now so that you can see my slides. Okay, hopefully you can see my slides. Someone will hopefully shout if not. Has that worked? Yeah, good. Okay, fantastic. As Katie said a moment ago, I'm going to be talking about the principles which apply when an insolvent a party in insolvent liquidation engages in adjudication. Now, there have been several important cases which have come out on this topic in the last few years. Most notably, the decision of the Supreme Court in Brescoe and Lonsdale, and the very recent decision of the Court of Appeal in John Doyle and Erith Contractors, together with many other first instance decisions. But I think it's important to say at the outset that standing back from all those recent cases, at a high level of generality, it has been the law virtually since the introduction of statutory adjudication in this jurisdiction that a claimant in insolvent liquidation who refers a claim to adjudication and gets a decision in their favour is in practice unlikely to succeed in enforcing that decision in court and actually getting their hands on the money. It isn't impossible, as we'll see, but there are and have always been a number of significant obstacles in the way of such a claimant, and that has been the law for 2 decades now, albeit that, as we'll see, the details and the intellectual foundations of that law have shifted to some extent. So there are 4 practical questions which arise, as it seems to me, when considering the position of a insolvent claimant as regards adjudication, which I've put on the slide. And they are: will the adjudicator have jurisdiction? If so, will the court nonetheless restrain the adjudication by injunction? If not, and a decision is produced, will the court summarily enforce the adjudicator's decision? And then finally, if summary judgment is granted, will the court nonetheless stay execution of the judgment? So will they prevent the claimant from actually taking steps to enforce the judgment and get their hands on the money? And what I'm going to do in the remainder of this talk is go through the key authorities on those questions, and then at the end come back to them and tell you explicitly, albeit in very summary form, what I think the answers are. So a quick roadmap of what we have ahead over the next 20-25 minutes or so. So first of all, I'm going to look at Rule 1425 of the Insolvency Rules and briefly the decision of the House of Lords in Stein and Blake. I'm then going to look at the decision of the Court of Appeal in Bouygues and Dahl Jensen. We'll then look at Bresco in the Court of Appeal and in the Supreme Court. And then finally, we'll look at the decision of the Court of Appeal in John Doyle, which came out about a month ago. So starting with Rule 1425 of the Insolvency Rules, this says that in a winding up, so where there are mutual dealings, i.e. claims and cross-claims between an insolvent company and one of its creditors, and I'll quote from the slide, an account must be taken of what is due from the company and the creditor to each other in respect of their mutual dealings, and the sums due from the one must be set off against the sums due from the other. So where a company is being wound up, it's in insolvent liquidation, and there are claims and cross-claims between that company and a creditor, this rule requires those claims to be set off against each other so as to leave you with a single net balance due one way or the other. And in Stein and Blake, Lord Hoffman explained how this works as a matter of legal analysis, and he did so by reference to the predecessor to Rule 1425 in the insolvency rules, but the principles are the same. And he said the conclusion must be that the original shows an action ceases to exist and is replaced by a claim to a net balance. If the set-off is mandatory and self-executing and results as of the bankruptcy date in only a net balance being owing, I find it impossible to understand how the cross-claims can, as shows is an action, each continue to exist. And we'll come back to that principle a few times later on. So that brings me on to the first adjudication case, which I'm going to look at, which is Bouygues and Dahl Jensen. So this was a claim to enforce the decision of an adjudicator concerning a full-blown construction dispute. There were revaluation claims, variation claims, delay claims, and a termination dispute on top of that. So lots and lots of claims and cross-claims between the parties. The adjudicator resolved those claims and cross-claims and produced a decision in favour of Dahl Jensen. Bouygues refused to pay, so the matter went to court, and Dahl Jensen obtained judgment. So far, so ordinary, you might think, but there was a problem, albeit only a problem identified in the Court of Appeal, which was that Dahl Jensen was in insolvent liquidation. So the principles we've just been looking at, Rule 1425, Stein and Blake, were brought into play. And Lord Justice Chadwick referred to the insolvency rules, he referred to Stein and Blake, and then he said this, and it's in the first paragraph on the slide: if Bouygues is obliged to pay to Dahl Jensen the amount awarded by the adjudicator, those monies, when received by the liquidator of Dahl Jensen, will form part of the fund applicable for distribution among Dahl Jensen's creditors. If Bouygues itself has a claim under the construction contract, as it currently asserts, and is required to prove for that claim in the liquidation of Dahl Jensen, it will receive only a dividend pro rata to the amount of its claim. And then importantly, it will be deprived of the benefit of treating Dahl Jensen's claim under the adjudicator's determination as security for its own cross-claim. And that's language we will see repeated again and again in these cases. It has the potential to be slightly confusing language. I find some people sometimes don't quite follow what's meant here. When he's referring to Dahl Jensen's claim as security for Bouygues' cross-claim, what he means is that we can use the money it would otherwise have had to pay to Dahl Jensen pursuant to its claim as security for its cross-claim. It can hold on to the money and use it as security rather than having to pay it across. And then we have the following statement of legal principle, which Lord Justice Chadwick gave in paragraph 35 of Bouygues. Where there are latent claims and cross-claims between parties, one of which is in liquidation, it seems to me that there is a compelling reason to refuse summary judgment on a claim arising out of an adjudication which is necessarily provisional. All claims and cross-claims should be resolved in the liquidation, in which a full account can be taken and a balance struck. That is what Rule 490, now 1425, of the Insolvency Rules 1986 requires. So that's entirely consistent with the logic of Stein and Blake. But what Lord Justice Chadwick did not make clear in these passages is whether or not an adjudicator appointed in such circumstances would have jurisdiction to decide a dispute. he didn't deal with that. He simply said that there would be a compelling reason to refuse summary judgment. And so the question of jurisdiction brings me on to Bresco, for which we have to jump forward some 18 years. So in very barest summary, Bresco was in insolvent liquidation and started an adjudication against Lonsdale. Lonsdale sought an injunction restraining the continuation of the adjudication on the ground that the adjudicator lacked jurisdiction in view of Bresco's insolvency. And so as we've just seen, that submission was consistent with Bouygues, though not explicitly supported by it, in as much as Lord Justice Chadwick didn't explicitly refer to jurisdiction in his judgment. Now, at first instance, Mr. Justice Fraser accepted that the adjudicator lacked jurisdiction by reason of Bresco's being in insolvent liquidation, and granted the injunction. And he said a company in liquidation cannot refer a dispute to adjudication when that dispute includes determination of any claim for further sums said to be due to the referring party from the respondent party. Now, in the Court of Appeal, Lord Justice Coulson disagreed with that in part. He held that an adjudicator does have jurisdiction to consider a claim advanced by a company in liquidation. So Mr. Justice Fraser was wrong about that at first instance. But importantly, he went on to hold that the adjudication and insolvency regimes were fundamentally incompatible. And it was only, and where a company was in insolvent liquidation and facing a cross claim, it would only be permitted to refer its claim to adjudication, obtain summary judgment, and avoid a stay in exceptional circumstances. The fact of the liquidation would usually be a compelling reason to refuse summary judgment as per Bouygues. And an injunction would be granted to restrain the continuation of an adjudication by an insolvent company if the court concludes that the nascent adjudication is a futile exercise. And in most cases, absent exceptional circumstances, the adjudication would be futile because any decision produced would be unenforceable. So on the facts, Lord Justice Coulson held that the injunction, restraining the adjudication should continue. So Mr. Justice Fraser's order was upheld in the result, if not for the same reasons. Bresco was in insolvent liquidation, and Lord Justice Coulson reasoned that any decision produced in the adjudication would not be enforceable, and the adjudication was therefore a futile exercise and should be restrained by injunction. So again, so far so good, or at least so consistent. There's a consistent line of reasoning reaching from Stein and Blake to Bouygues to Bresco in the Court of Appeal. But then we get to the decision of the Supreme Court in Bresco, and it all just starts to go wrong. So Lord Briggs agreed with the Court of Appeal that an adjudicator has jurisdiction to consider a claim advanced by a company in liquidation. But he rejected the Court of Appeal's conclusion that an adjudication brought by a party in insolvent liquidation will, absent exceptional circumstances, be restrained by injunction as an exercise in futility. On the contrary, he said, and I've put this on the slide, the insolvent company has both a statutory and a contractual right to pursue adjudication. It would ordinarily be entirely inappropriate for the court to interfere with the exercise of that statutory and contractual right. So an emphatic rejection of Lord Justice Coulson's conclusion as to whether restraint by injunction would be appropriate. And he then went on to reject the Court of Appeal's conclusion as to futility on two grounds. First of all, he said that adjudication has utility even where the decision is not summarily enforceable because it's a method of dispute resolution. So that's the second paragraph on the slide. So he said, in the context of construction disputes, adjudication has become a mainstream method of ADR, leading to the speedy, cost-effective and final resolution of most of the many disputes that are referred to adjudication. Dispute resolution is therefore an end in its own right, even where summary enforcement may be inappropriate or for some reason unavailable. Now, this needn't detain us for too long, but for what it's worth, I think this is absolute nonsense. Adjudication is popular as a method of dispute resolution in large part because adjudicated decisions are summarily enforceable, and the number of contested adjudication enforcement hearings is testament to that. the idea that adjudication would be anything like as mainstream, to use Lord Briggs's term, as it is now, if adjudication decisions could not be summarily enforced, and so were more like a sort of early neutral evaluation or some other non-binding process like that, is just obviously wrong, in my view. The summarily enforceable quality of adjudication is the reason it is so popular. But anyway, that's that. So that's Lord Briggs's first ground for rejecting the Court of Appeal's futility argument. The second ground on which Lord Briggs held that adjudication by a claimant in insolvent liquidation would not ordinarily be futile, so as to justify granting an injunction, was that in some circumstances, he said, summary enforcement would be available. And this, I think, is really the trickiest part of Bresco, because with the best will in the world, it's really quite difficult to see what Lord Briggs is getting at in this passage. He starts by saying, and I've put this on the slide, that summary enforcement will frequently be unavailable. He expressly approves Bouygues, and that's in the first paragraph on the slide. Absolutely unambiguous. But then he goes on to say this, second paragraph. Furthermore, it will not be in every case that summary enforcement will be inappropriate. And well, hang on. That seems to be diametrically opposed to what Bouygues says, but let's carry on. There may be no dispute about the cross-claim, and the claim may be found to exist in a larger amount, so that there is no reason not to give summary judgment for the company for the balance in its favour. Or the disputed cross-claim may be found to be of no substance. Or, and I've underlined this bit because it's the most confusing bit, I think, or if the cross-claim can be determined by the adjudicator because the claim and cross-claim form part of the same dispute under the contract, the adjudicator may be able to determine the net balance. If that is in favour of the company, there is again no reason arising merely from the existence of cross-claims why it should not be summarily enforced. So Lord Briggs gives three scenarios here. The first scenario is where there's no dispute about the cross-claim, and the second scenario is where the disputed cross-claim is found to be of no substance. Well, both of those can be kind of lumped together and put to one side almost, because they are really equivalent to a situation where there is no live cross-claim. It's either an agreed cross-claim or a cross-claim which has no substance. So it's the third scenario which interests us, I think, and that's where the cross-claim and cross-claim have been decided by the adjudicator and the net balance determined. And Lord Briggs says that in that scenario, summary judgment may be appropriate. Now, what Lord Briggs is really saying here, as it seems to me, is that if the disputed cross-claim is decided in the adjudication, it will no longer be possible to rely on it as a defence to summary enforcement. And that is problematic for several reasons. First of all, it doesn't sit well with Bouygues, as I've already identified. The claims and the cross-claims in Bouygues were all dealt with in the adjudication. Lord Justice Chadwick held in that case that was a compelling reason to refuse summary judgment. Now, Lord Briggs seems to be saying that on materially the same facts, summary judgment might be appropriate. Now, this is confusing. And it's made still more confusing by the fact that, as we've seen, as you can see on the slide, in literally the preceding paragraph, Lord Briggs says that he agrees with Bouygues. It's also unclear why a distinction should be drawn between a cross-claim that is determined in the adjudication and a cross-claim that isn't determined in the adjudication. The point made in Bouygues that enforcement of the decision deprives the responding party of the security for its cross-claim applies with equal force whether or not the cross-claim is dealt with in the adjudication. And then finally, the proposed distinction which Lord Briggs draws between cross-claims advanced in the adjudication and cross-claims not advanced in the adjudication is liable to create an undesirable situation where responding parties with cross-claims might choose not to raise them in adjudication so that they can rely on them later to defeat enforcement. And similarly, referring parties would be put under pressure to frame their disputes as widely as possible when referring matters to adjudication, so as to capture all possible claims and cross-claims that might otherwise be raised by responding parties on enforcement. So this paragraph has the potential to have a real distorting influence on the way parties present and seek to enforce their claims in adjudication. But happily, there is now, that's not the end of the story, which it used to be when I gave a talk a bit like this, because we now have the decision of the Court of Appeal in John Doyle, which does go some way to clarifying this. So the appeal in John Doyle was from an order of Mr. Justice Fraser dismissing John Doyle's application for summary enforcement of an adjudicator's decision on the grounds that it was in liquidation. Most of the appeal and most of the judgment was concerned with the adequacy of security which John Doyle offered in an attempt to obtain summary judgment and avoid a stay. But as Lord Justice Coulson noted in paragraph 2 of his judgment in attractively dramatic terms, was lurking in the shadows of this appeal is a wider point as to whether a company in liquidation with an adjudication decision on its final account claim in its favour, but facing a continuing set-off and counterclaim, is entitled to summary judgment at all. And now, as we've seen, that issue arises in light of first Bouygues, in which, as we've seen, the Court of Appeal held that the answer to that was no, and then Bresco, in which Lord Briggs, again, as we've seen, approved Bouygues, but then went on to set out what was at first blush a very wide exception to the rule established in Bouygues. And then in the second paragraph I put on this slide, Lord Justice Coulson goes on to identify paragraph 65 in Bresco, which is the paragraph we've just been looking at, and identifies it as posing some difficulty. It says Lord Briggs gives examples there of cases where summary enforcement will not be inappropriate. It is the third example, that's the one that I was just talking about, which is more problematic. That, in the word of Lord Briggs, is where the cross-claim can be determined by the adjudicator because the claim and cross-claim form part of the same dispute under the contract. He says that in those circumstances, the adjudicator may be able to determine the net balance. And he goes on to identify the difficulty. The difficulty is that, on the face of it, Lord Briggs's third example takes no account of the fact that an adjudicator's decision is necessarily provisional and cannot therefore be regarded as the final determination of the net balance. To put the same point another way, the third example used by Lord Briggs at paragraph 65 would appear to run counter to the reasoning and the result in Bouygues, where summary judgment was refused. Now that is, of course, the very point we made a few minutes ago when we were looking at this paragraph in Bresco. It's inconsistent with Bouygues. Well, how does Lord Justice Coulson square this circle? Bresco is Supreme Court authority. This paragraph, it probably isn't part of the ratio, but it's at the very least highly persuasive coming from a senior appellate court. What does Lord Justice Coulson do? Well, he says this: taking it in the round, I do not believe that Lord Briggs was saying in his obiter observations about enforcement that a company in liquidation was entitled to enter judgment, let alone recover the monies that were the subject of that judgment on the basis of a provisional decision in circumstances where there was a continuing set-off and cross-claim. He did not suggest that there was any right to enforce a claim which did not take into account the set-off and cross-claim. On the contrary, he expressly approved MS Fashions, a case we haven't looked at today, and Stein and Blake. Neither was he saying that, contrary to what Lord Justice Chadwick said in Bouygues, summary judgment should be granted and enforced on a claim arising out of an adjudication which is necessarily provisional. On the contrary, he expressly approved what Lord Justice Chadwick had said in Bouygues. Now, so what he does is he says, well, that's not really what Lord Briggs was saying. Lord Briggs wasn't really saying that you would get summary enforcement in that situation. So I thought we could just test that by putting these two extracts from the two judgments side by side on a slide. So I've got what Lord Briggs said in Bresco on the left, and I've got what Lord Justice Coulson says Lord Briggs said on the right. So on the left, Lord Briggs says that if the cross-claim can be determined by the adjudicator, there is no reason arising merely from the existence of cross-claims why it should be summarily enforced. And then on the right, Lord Justice Coulson says I do not believe that Lord Briggs was saying in his overture observations about enforcement as a company in liquidation was entitled to enter judgment in circumstances where there was a continuing set-off and cross-claim. Well, I will let you make up your own minds as to whether or not that is what Lord Briggs was saying, in fact. But in some ways, Lord Justice Lewison has done my job for me, because in his judgment in John Doyle, he put the point rather more bluntly. Despite having approved Lord Justice Chadwick's observation in Bouygues that the mere fact of insolvency set-off is itself a compelling reason for refusing summary judgment, Lord Briggs went on to suggest that it might be done. Quite. So the Court of Appeal's conclusion in John Doyle was that the court would generally not summarily enforce an adjudicator's decision in favour of a claimant in insolvent liquidation where the other party has a cross-claim. And as the court said, that is consistent with the analysis in Bouygues that we identified right at the start of this talk, and that's confirmed by the first paragraph on the slide. And Lord Justice Coulson, importantly, I think, then went on to justify that conclusion by reference to the insolvent company's cause of action being for the net balance only. If you can see that in the second paragraph on the slide, the highlighted words, it's a question of the insolvent company's cause of action being for the net balance only. So that's a direct reference back to the logic of Stein and Blake, i.e. where Rule 1425 applies, the claims and cross-claims are merged into a net balance due one way or the other, and the underlying claims and cross-claims are extinguished, they cease to exist. So where we end up, I think, is that a claimant in insolvent liquidation seeking to enforce an adjudicator's decision in a situation where Rule 1425 and the logic of Stein and Blake apply, well, the adjudicator will not lack jurisdiction by reason of the application of Rule 1425. See Bresco, we've looked at that. The adjudication will not be rendered futile and so be liable to restraint by injunction. Again, see Bresco in the Supreme Court. But the court will usually refuse summary judgment as a result of the application of Rule 1425. See John Doyle, which we've just been looking at. Now, I think the final point to make on this is that it's not a case of, I don't think it's a blanket rule that you will never get summary judgment if you are a claimant in insolvent liquidation seeking to enforce an adjudicator's decision. The language used in John Doyle is that of usually, or what the norm is, or what will generally be done. So that there are possible exceptions, although they're not stated clearly in John Doyle. Well, when will summary judgment be available to an insolvent claimant? Well, it seems to me that the answer to that one has to go all the way back to Bouygues, to paragraph 35, which I've put on the top of the slide, where Lord Justice Chadwick said, where there are latent claims and cross-claims between the parties, one of which is in liquidation, it seems to me that there is a compelling reason to refuse summary judgment on a claim arising out of an adjudication which is necessarily provisional. Well, it seems to me that that gives us two scenarios in which summary judgment might be available. The first is where there is no cross-claim. So there's just a claim brought by a claimant in insolvent liquidation. In the absence of a cross-claim, the logic of Bouygues does not apply. Rule 1425 doesn't make any difference, and there's no reason why summary judgment shouldn't be granted in that situation, subject to questions of security and a stay. The second situation is where the adjudication is not provisional, and that arises out of the final words of the quotation from Bouygues on the slide. So adjudication which is necessarily provisional. Well, it's not necessarily provisional because parties can agree to give the adjudicator jurisdiction to make a final decision. And that scenario was envisaged by Lord Justice Coulson in John Doyle, paragraph 93. I've put that at the bottom of the slide. I quite accept that in circumstances where the adjudicator has, by express or tacit agreement, finally decided the net balance between the parties, then the consideration would move to security issues. So those are two scenarios where I think summary judgment might still be granted, notwithstanding the decisions in Bouygues and now in John Doyle. So finally, just to wrap up, I promised I'd come back to these questions at the end. So if a company in insolvent liquidation refers to a dispute to adjudication, will the adjudicator have jurisdiction? Yes. See Bresco, that is the answer now. There's no more to it than that, really. If so, will the court nonetheless restrain the adjudication by injunction? Very unlikely to do that. Again, see Bresco. The language used by Lord Briggs is that it would ordinarily be entirely inappropriate for the court to interfere with that contractual and statutory right, i.e. the right to adjudicate. So again, if you're seeking to restrain an adjudication on grounds like that, grounds of that kind, you're on in very difficult territory, in my view. Third, if not, will the court summarily enforce the adjudicator's decision? Well, the answer to that is usually no, and we know that because of Bouygues, and it's now been confirmed by John Doyle. And as I've just said, there are, I think, two possible exceptions to that. The first is where there's no cross-claim, and the second is where the parties agree that the adjudicator can finally decide the net balance due between them, rather than only provisionally deciding it. And then finally, will the court grant a stay of execution of the judgment? We haven't looked at stays in any great detail, but the import of John Doyle, I think, is that questions of security are likely to be considered at the stage of whether to grant summary judgment now. So in effect, if you have got summary judgment and the court is satisfied that adequate security has been provided, then it would be strange for the court to nonetheless go on and grant a stay. So that the questions of summary judgment and a stay are in large part likely to run together now, I think. So with that exciting conclusion, that's the end of my talk. So thanks very much for listening, and I'll hand over now to Tom, who's going to talk to you about liquidated damages.
Yeah, thanks, Harry, for that enjoyable demolition of Bresco in the Supreme Court. Let me just share my screen. Now, is that hopefully Harry will shout if you can't see my slides. Yeah, so yeah, thanks very much for having us along this evening. It's yeah, great to be here. And so yeah, as Harry said, I'm going to spend 20 minutes or so looking at some recent developments in the law relating to liquidated damages, and it's appropriate to start off by asking ourselves why cases on liquidated damages are like buses. And the answer, of course, is that you wait for ages for one to turn up and then two come along at the same time. The two cases that I have in mind and going to talk about this evening are the ones on the slide. The law relating to liquidated damages is, generally speaking, pretty settled. I do the chapter in Keating about liquidated damages, and so can say that happily the law on liquidated damages doesn't really change that much. It's pretty rare that there's an important case that comes out on LDs, and actually it's striking that in the current edition of Keating on construction contracts, the text that deals with the law on liquidated damages is to a significant extent the same as it was in the very earliest editions of that book, in the date from the 1950s and 1960s. But these two cases between them deal with three of the classic debates and controversies in the law relating to liquidated damages and penalties. And so it's worth looking at them. Because the decision of the Supreme Court in Triple Point, the second of those cases, is, I think it is better known and has been far more widely commented on so far, I thought it'd be better to start with the decision of Mrs. Justice O'Farrell in EcoWorld and spend a bit more time on that, and then come back to Triple Point more briefly at the end. So EcoWorld, this was a dispute arising out of a development known as Embassy Gardens Phase 2, part of this huge redevelopment at the Nine Elms site just south of the river in London. This may actually be an image of Phase 1 of that development, but you get the basic picture. It is posh, expensive flats. EcoWorld was the employer, and Dobler was the contractor, trade contractor, who'd been engaged to design, supply and install the facade and glazing works for part of the development. The contract was on the JCT Construction Management Trade Contract 2011 standard form, but subject to a series of bespoke amendments in the usual way. And it contained all the sorts of usual provisions in terms of that the contractor was to complete by the completion date. Then there was an obligation to pay liquidated damages if there was a failure to do so, and it had the normal terms in relation to practical completion, etc. But the contract also contained this provision, which is on the slide, in relation to taking over of part of the works, effectively sort of early partial possession. So if at any time or times prior to the date of issue by the construction manager of the certificate of practical completion for the works, or such works in a section that the employer wishes to take over, any part or parts of the works, or such works in a section, then, notwithstanding anything expressed or implied elsewhere in this trade contract, the employer may take over such part or parts. And then there were some further provisions that we don't need to worry about. So that was the power to take early possession. The contract also contained this provision in relation to liquidated damages. The following rates of liquidated damages will apply for the first 4 weeks, inclusive of delay, in completion of the works beyond the date of completion, £0 per week. But then liquidated damages will apply thereafter at the rate of £25,000 per week, up to an aggregate amount, a maximum of 7% of the final trade contract sum. So basically the contractor didn't have to pay LDs for the first 4 weeks. Then it had to pay LDs at the rate of 25 grand a week for each further week of delay, but only up to a maximum of 7% of the contract sum. Well, so far so good. Dobler commenced the performance of its works, but there was a significant delay. And what ended up happening was that in June 2018, the employer took over certain blocks in the development, but not others. And practical completion of the whole of the works, it didn't take place then until, I think it was December 2018. It's about 6 months later. And the parties then fought a series of adjudications regarding the value of the final account, which I don't think we need to go into in detail for present purposes. The dispute that eventually came to the TCC arose out of the interaction between the two contractual provisions we've looked at, namely this liquidated damages provision on the slide and the partial possession provision that we looked at. And as you will no doubt have anticipated, the basic point was that the calculation of liquidated damages did not contain any mechanism for dealing with the possibility that the employer might take over part of the works. And even where that happened, the contractor would, at least on the face of it, still have to pay liquidated damages at the same rate, even if the same rate that would apply even if none of the works had been taken over by the employer. It was EcoWorld, so the employer, that started these Part 8 proceedings in the TCC. And so it was the employer's position, EcoWorld's position was as follows. It contended that the liquidated damages provisions in the contract were void and or unenforceable. And the argument it made was that as a matter of law, where an employer under a construction contract has and exercises a contractual right to take early possession, but the liquidated damages provisions don't contain a mechanism for reducing the level of LDs that are paid to reflect that early possession, the liquidated damages provisions amount to a penalty and are therefore void or unenforceable pursuant to the penalty doctrine. And it followed, EcoWorld said, that it was entitled to claim general damages for delay. It could claim whatever its actual loss was that it had in fact suffered as a result of the contractor failing to complete by the completion date. Dobler's position was as follows. First, it argued that the LD's provisions weren't void or unenforceable. And second, it argued that even if it was wrong about that the liquidated damages provision still operated as a cap or a limit on its liability for general damages for delay. And so those two arguments gave rise to what I'm going to call issues 1 and 2. And there's various other arguments in the case, but we don't think we need to look at them for present purposes. But it's worth noting, as I'm sure will be obvious, that the position that was adopted by the parties here was the opposite of those which you might expect them to have taken, i.e. it was the employer arguing that the LD's provision was unenforceable. And although it's not completely clear from the report, at least you can piece together that effectively that was because the employer took the view that the losses which it had actually suffered as a result of the delay were going to be, or were substantially more than the 25,000 a week of LDs that were inserted in the contract, and or substantially more than 7% of the contract sum. So it thought that it was in its interest to run this argument. EcoWorld relied on a number of authorities in support of its main argument on this issue 1, and interestingly, it placed particular reliance on passages in Keating and Hudson, which did suggest that where an employer takes early partial possession and there isn't a mechanism for reducing the amount of LDs payable, that a claim for liquidated damages may well fail because it's a penalty. And it also relied on and one of the classic cases on this topic, really, particularly Bramwell and Ogden, which is often relied on, as I'm sure many of us will have seen in adjudication and in arbitration, normally by contractors or subcontractors seeking to argue that their LD's provision is unenforceable and a penalty because there's no account is taken of the possibility of this early partial possession. Mrs. Justice O'Farrell, who dealt with the case, subjected to those authorities to a detailed and careful analysis, and she concluded that the cases didn't actually support the propositions of law for which they're often cited. She said, the key bit of her reasoning is the bit set out on the slide. The courts did not reject as automatically fatal the concept of one rate of liquidated damages applying for late completion of the works where there is sectional completion or partial possession. Rather, the express provisions in each case simply did not work because of errors in the drafting, and that's references back to the authorities the earlier cases relied on. And so she pointed out that the ratio of those decisions was really very limited, and it was limited to a finding that the particular contractual provisions in those cases didn't work and didn't make sense, and so therefore void for uncertainty. And when one looks at the cases, it's pretty hard to disagree with her. So that left matters in a position where there wasn't any direct authority for the proposition of law dealing with partial possession that the employer was relying on. And so the court said that the issue that arose was whether the liquidated damages provision was a penalty, but that fell simply to be determined by the application of the penalty test now identified in the Supreme Court case in Cavendish. And what the Supreme Court said in Cavendish was that the true test for whether a liquidated damages provision is a penalty is whether it imposed an obligation to pay an amount that is unconscionable or extravagant or exorbitant when compared to the legitimate interest of the innocent party in the other party performing its primary obligations. That's the test for a penalty set out in Cavendish. Now, Mrs. Justice O'Farrell acknowledged that one of the propositions of Lord Dunedin in the older cases, Dunlop, etc., was that there was a presumption that where you had a single lump sum that was payable on the occurrence of one or more several events, some of which were serious and others less serious, there was a presumption that was a penalty. But she emphasised here that applying the test in Cavendish, the LD's provisions weren't unconscionable or extravagant or exorbitant, and so she said that the clause wasn't penal. She identified 4 key reasons for that, which is worth just noting briefly because they're likely to arise in a lot of cases. First, she said it was important that the LD's provisions had been negotiated by the parties with the benefit of external lawyers. She made the point, secondly, that the employer had a legitimate interest, that's the language of Cavendish, a legitimate interest in enforcing the contractor's primary obligation to complete the whole of the works by the completion date, and that taking partial possession didn't change that. And she made the point, thirdly, that quantification of damages will be difficult. Fourthly, she said that there was no evidence before her that the damages at a rate of £25,000 per week was unreasonable or disproportionate. And so those were the 4 key reasons that she gave for reaching her decision on the penalty issue. In terms of the sort of key points to take away from this part of the decision, I think the most obvious one is that the decision does make it far harder for parties, normally contractors, to succeed with the old Bramall and Ogden partial possession type arguments. I mean, winning a penalty argument in a construction dispute has long been difficult, but a failure to account for sexual completion or partial possession was one area in which those arguments could gain some traction. But this decision does significantly change the landscape and makes it likely it's going to require some very strong facts to persuade a tribunal that the failure to account for partial possession in the rate of LDs makes that a penalty. And more generally, we could see the decision as showing that the impact of the earlier Supreme Court decision in Cavendish, showing the practical impact of that's having in real world disputes. There's certainly a case that could be made for saying that the decision in this case might have been different under the old law, with its emphasis on whether the LDs constituted a genuine pre-estimate of loss. If that was the test, the outcome of this dispute might well have been different. So we can see that, as was predicted, the decision of the Supreme Court in 2015 in Cavendish, Deci, is having a real world impact. Briefly, it's worth looking at the second issue. Very briefly, the contractor advanced an alternative case and said if it was wrong about the first issue, then the liquidated damages operated as a cap or limitation on its liability for general damages in any event. The judge identified that all of the leading textbooks that I've identified on the slide took rather different views on this question. McGregor has always said that it doesn't operate as a cap. Chitty says that it might do, and Keating and Hudson have both said for many editions that it should operate as a cap. In this judgment, Mr. Justice O'Farrell concluded that the liquidated damages clause would have operated as a cap. And she emphasised that it's always going to be a question of construction of the relevant clause in each particular case, and that every case would be different. And she also based her reasoning in part on the way the clause was worded, which we've looked at already. And she was talking particularly about the wording at the very end, talking about 7% of the final contract sum. And she said, well, that must be seen as the purpose of that was to agree a cap. But it's nevertheless interesting that she came down firmly on that side of what is a long-standing debate that's been conducted in some of the textbooks. And this was the core part of her reasoning on this issue. And it's worth noting because this reasoning is likely to be applicable to the vast majority of building contracts. The purpose of liquidated damages is second to limit the contractor's overall liability for late completion to a specific percentage, or in other cases to a specific amount. So the reasoning is likely to be applicable more widely, and cases on this issue are rarer, and so it's certainly useful, I think, for contractors to know that decision is out there, and it points to the way in which this issue will be answered if and when it comes up, which it does do from time to time. I'm conscious of the time, but as I promised 2 cases, I'll deal with Triple Point very, very briefly. I'm sure many of you will have seen or read about the dispute this dispute, Triple Point, at some point during its progression through the courts, and I won't go into the background. But the only relevant facts that you need to know for present purposes are that the contract imposed an obligation on the contractor to pay LDs if it failed to complete. The completion date was then passed, the contractor hadn't completed, and then sometime later the contract was terminated. And the issue that arose on appeal was whether the employer was entitled to liquidated damages in those circumstances. And the Court of Appeal identified that there were 3 different answers or possible answers to that question, each of which was supported by different strands of authority, which were directly inconsistent or conflicted with each other. And so it identified that option 1 was that the answer was that there was no obligation to pay LDs arose at all unless the contractor in fact completed the works, albeit late. And so there was no entitlement to LDs, even in respect of the period between when completion should have been and the date of termination. And that was the answer that the Court of Appeal in Triple Point gave as the correct answer. It identified that there was another possible answer, though, what I've here called option 2, which was that the employer would continue to be entitled to recover liquidated damages in respect of delay all the way from the completion date up to the date at which the works were in fact completed by a replacement contractor. And somewhat surprisingly, there are authorities which have so held, a number of them. Then there was option 3, which was that the employer was entitled to liquidated damages in respect of that period, a period of contractual culpable delay, up to, so from the date of when completion should have taken place, up to the date when the contract was terminated, but then was only entitled to general damages thereafter in respect of losses flowing from the termination, including in respect of delay. So that's what I've called option 3 here. So in the Supreme Court said, yes, it's a question of construction of the contract, but basically all other things being equal, it's going to be option 3. And I've set out on the slide, perhaps where this point is made clearest. I would suggest that that's entirely unsurprising analysis, that option 3 is correct. Clearly, the employer should be entitled to retain those liquidated damages that have accrued to it in that period between when completion should have taken place and then when the contract is terminated. But at that point, the contractor's obligation to complete the work ceases, and so it can't have any further entitlement to liquidated damages. And so happily, the Supreme Court, at least in this case, has helped us all out by clarifying the law, setting it back to where we started. And so, yeah, I mean, the 2 key points I think to take away from Triple Point. First, it's back to where we thought we were before. If you looked at the textbooks until the Court of Appeal decision, they were pretty clear that it was option 3 that was the correct answer. But now we've got Supreme Court authority for that. But secondly, whilst it's worth noting that whilst the Supreme Court said, well, it's going to be a case of the proper interpretation of each contract, and so you have to work that out on a case-by-case basis. For practical purposes, it's pretty clear that the answer is settled. The answer is option 3, and the Supreme Court noted expressly that the contractor hadn't been able to put before it any examples from any standard form of building contract where there was a different result, and so that makes it extremely unlikely that the conclusion is going to be different in any other case, at least that's using a standard form, a standard form of building contract in this jurisdiction. Thanks very much for listening, everyone. We haven't left a huge amount of time for questions, but I'm sure Harry and I will be very happy to answer any questions that anyone does want to ask, for as long as people want to stay and listen and ask those questions. Albeit I think that Harry said that he's going to deal with any difficult questions.
Thanks for that, Tom. I think there's a couple of hands up. So what we're going to do is, if you can pop the questions that you want to ask into the question and answer box, we'll deal at the bottom. We'll deal with as many of them as we can in the time. Whilst people are putting those in, Harry, if I come to you first, given what you've said about insolvency and adjudication, do you have any general advice for parties who become engaged in adjudication with an insolvent party? Is there anything they can do to protect their position, or is it just a case of waiting for enforcement stage?
Well, I don't think there's a huge amount you can do immediately, in the sense that it's now clear that the adjudicator will likely have jurisdiction and that seeking an injunction is unlikely to work. So I don't think there's a quick fix in that sense. But what you can do is write to them early on and make clear that you will be resisting enforcement when it gets to court, and that you will be insisting on the provision of full security and so on, and make clear that you're going to make it as difficult as possible for them to actually get their hands on any money. So, and that may well act as a deterrent to sensible parties. But I don't think there's a way you can just push it off from the outset, no. Okay, great. Yeah, if you do have questions, please post them in the chat, and we'll, in the question and answer section, we'll try and pick them up. Tom, for you, looking at drafting liquidated damages clauses, do you think parties should be more carefully considering terms such as possession, handover, takeover, sectional completion, those sorts of things at drafting stage?
Yes, and I think it's probably the case that quite often that is done, actually. And, in certain respects, it's always better, if it's possible, to apply one's mind to that at the outset and to try and have an agreed regime that deals with it expressly. And then you won't, or are less likely to get disputes of this sort. Having said that, I think it's that the decision in EcoWorld does mean that those sorts of issues are just going to be less important. It's going to be far harder for a contractor to, or either party, it was the employer in EcoWorld, but either party to say that the LD's provision is deficient, unenforceable, penal, on the basis that it doesn't deal with the partial possession or sectional completion point. So whilst it's always a good idea to think about these things if possible in the contract, in a sense, the big point from the decision is that those kind of arguments aren't going to get off the ground, and so it's not something that that perhaps people need to parties need to worry about in quite the same way as they would have done before. And I think it's probably the case that a lot of the drafting that is included by parties dealing with this point is was precisely because of those earlier cases like Bramall and Ogden, which seem to give rise to those sorts of arguments. So in some respects, it might be sort of back to where we were, or where things were 40 years ago.
Mm-hmm. Okay, great. And I think kind of one last question that we've got here, does the situation in respect of partial possession also apply in respect of sectional completion?
Yeah, I mean, I suppose the correct answer is that it all really depends on the particular contract in question in the case. But I think the short answer is yes, and that it doesn't really, I don't think there's a distinction as a matter of sort of principle between partial possession and sectional completion. The arguments that were available to be made in respect of penalty were the same really in both cases, and the reasoning and approach of Mrs. Justice O'Farrell in EcoWorld it doesn't distinguish between them really. That reasoning would be just as applicable to sectional completion as it would to partial possession.
Okay, great. I think we've got one last one that's just snuck in there. In Cavendish, how did they say you'll determine what was exorbitant other than by reference to likely costs?
I mean, I think the short answer is that they don't really say. I think what they envisage is a comparison between, on the one hand, what the LDs say you have to pay, and on the other, what they would call the legitimate interest of the innocent party in obtaining performance of the other party. So it's not a sort of financial comparison, it's sort of a comparison between, well, how much the LDs are on the one hand, and then in putting it in crude terms, how important it is to you that they comply with their obligations. In respect of, in this case, completing on time, which is a slightly tricky determination or comparison that has to be made, certainly as compared to the old law when you were asking yourself, well, is it a genuine pre-estimate of loss? It does mean that the decision is rather woollier because it's, well, is it unreasonable, exorbitant, extravagant? It makes it much harder to say that anything is a penalty, at least in my experience.
Great. Well, I think that's the end of the questions. So I'd like to thank both Harry and Tom for their time tonight and their hard work in putting this together. The Chartered Institute of Arbitrators Northwest Branch next event is on the 25th of November at 9:30, discussing low cost adjudications. And more details can be found on our social media pages for that. So thank you very much, Harry. Thank you, Tom, and to Keaton for hosting. And hope everyone has a lovely evening.
Cool. Thank you very much.
Thanks very much, Katie. Cheers.
Bye now.